bucket, your investments, and
Turn this way, Gersh.
forgive me because I know your house doesn't look like this, but you know, sometimes even the home.
Mine does.
Yeah, it does.
It does? You have the chimney? Okay.
It looks very similar.
Okay. If you have any business interests, it's very important that we put your stock or your LLC membership interest into the bucket or trust as well. Okay? So you write rules on your bucket, and you need a trustee to run your bucket. Okay? Well, very simply, the trustee, well, that's you. Okay? And you can act with a co-trustee, or not. Perhaps your spouse, perhaps an adult child, a parent, a sibling, anyone that you wish, or you can act alone. What's nice about a trust versus a will is that if you fund your bucket properly, anybody know about this place? It won't go here. Probate.
Probate.
court.
Yeah.
Okay, we don't want to go here, okay? Trusts never die, so they never have to go through probate. You only have to go through probate if your assets are in your name alone when you die, or you become incapacitated and can't manage them, okay? This place charges fees, which is lovely. They have an inventory tax. I think we did that N upside down. Anyway, because of that, I put barbed wire around this place, and I never let my clients have to go here if at all possible.
Thank you, sir.
I try. So, so we try not to go there. So, yes, it's red, horrible probate
really
court with
impressed
the barbed wire around it.
The upside down driveway.
That's what I was noticing.
At all costs, we try to avoid it.
No, upside down.
So if you create your bucket properly, during lifetime, if you become incapacitated, your co-trustee, or you could name a successor trustee, it's up to you, anyone that you wish can manage the assets in your bucket for you if you're unable to do it yourself. Okay? Now, that's part one, or chapter one, okay? When you die, you decide who receives your assets. Okay? How they receive your assets. You want to leave something to charity, you want to leave to children, to loved ones, to your spouse, to whomever you wish, in any way you wish, you can do that, and you never have to go to the red place. Okay? Because the trust never dies, you never have to go there. Okay? So far, so good? All right. Now, unfortunately, I'm going to draw in the red place. All right. I would suggest that you have a will. Even if you have a trust, everyone should have a will. Now, the purposes of the wills that I draft for my clients are basically if you forgot to transfer something into your bucket during your lifetime, we have no choice but to wash it through this red place. Okay? You bought a piece of stock and you forgot to transfer it into your trust. More likely, if the circumstances of your death gave rise to either wrongful death or medical malpractice, we have no choice but to go to the red place, run it through here. But this will is different than the kind of will that you may have now or that you've heard of. This will says, executor, pay the proceeds of my will, anything that comes into my probate estate, pour it over to my bucket, and then carry out the terms of my bucket. And you probate court, red place, are not privy to my plan of distribution. I'm not going to tell you all the ins and outs and the machinations of everything I did in my bucket. It's none of your business. Just pour it over. Okay? All right. I'm running out of room here. Okay. So, lifetime incapacity documents. Go ahead. I'm sorry.
If you do that, then whatever's in that will in there, put it into your bucket. Then you don't have the fees and the money that goes to the probate?
Unfortunately, anything that goes through the red place, you do have to pay the fees. What we want to do is structure your bucket so that you have the majority of your assets in the bucket, or the bucket is the beneficiary of your assets.
Okay.
so that you don't have to go here. If the circumstances of your death have led to wrongful death or medical malpractice, we have no choice.
It's already in.
Those comes post-death. So they have to be washed through the red place.
Okay,
So we have no choice.
okay.
But they don't need to know the plan of distribution of your trust and what you wish to do. Particularly if you need to disinherit people and you want to do that, it makes it a lot easier.
Don't you have to pay taxes on your trust?
Yes, your trust, this particular trust is a grantor trust, so it's taxed in your social security number. But we can talk about estate taxes too. There's no estate taxes between spouses. Okay, so if you're married in Rhode Island, if wherever you were married validly in the United States, Canada, Spain, Netherlands, places like that, and the marriage would be recognized in Rhode Island, you have the unlimited marital deduction. If you die in Rhode Island, there's no estate tax. Federally, because of U.S. versus Windsor, there's no federal estate tax. Yay. So it's huge. Between spouses, you can pass what you wish. You have a coupon. If you're single or you're widowed, you can pass federally $5.2 million before there's an estate tax. And in Rhode Island, God forbid they came up with a flat number. Lucky you!
5.1, man.
Yeah.
5.1.
Keep that number in mind. Don't Rhode Island is cheap. Their coupon couldn't possibly be a flat, simple, cool $1 million. It's like $924,725. I haven't memorized the new one come January 1st, but it's below $1 million. But if you want to pass that amount of money, and that includes proceeds of life insurance policies, retirement accounts, anything that you have, if you want to pass that to a non-spousal beneficiary, if you're over $1 million, you want to get a little legal advice because we have ways that we can minimize or eliminate that estate tax to a non-spousal beneficiary. But between spouses, you don't have the estate tax issue. So that's a good thing. Did that answer your question?
Everything that's in a trust, you said it's taxed to your social security number, so
Yeah.
there's no difference. For why you own it, the taxes are the same. whether
Income
you-
tax wise, yes.
Yeah,
And then when you die, it's estate tax, unless you go with the
Right.
irrevocable trust.
right.
Right.
And you used the term grantor trust.
I did. The grantor trust, that, under the IRS code, what that means is that the trust, this is a typical revocable trust, meaning it's changeable by you at any time. It's taxed under your social security number. So when you die, if you have an estate tax, it would still come through, depending upon who you're leaving your assets to. Now, there's a lot of other different kinds of trusts. I was just going with the low level because it's a Saturday night and I didn't want to bore you with the irrevocable trust and all the other trusts that we could do that are not taxed in your social security number as well. Power of attorney, while you're alive, if you become incapacitated, if you don't keep everything in your bucket, and we would never advise that you put retirement accounts in your bucket while you're alive, you need someone to manage them for you so that you don't have to go to the red place. Because during your lifetime, that's a guardianship. And you don't want to have to do that. You want whoever you name, your spouse, your loved ones, to not have to go there. So you name someone who's power of attorney to manage your assets that are held outside of the bucket for you so that we don't have to worry about, again, the red place. But you have to keep that document up to date. The IRS doesn't accept it after 3 years, so it's really important to keep your estate plans up to date. Okay? And then lastly, well, not lastly, but it's Saturday, so I don't want to bore you people. A suite of healthcare documents is really important. HIPAA is the Federal Privacy Act of Congress that you can thank Bill Clinton for passing. Keeps your health information so private that nobody can get access to it. So you said, thank you, Bill, that was great, but I want anyone that I'm named as my fiduciaries, my trustees, my powers of attorney, and the people that I love, I want them to have access to my medical records and billing. So you want to have a HIPAA release form, you want to have a healthcare proxy, which would state your wishes if you could not speak regarding a temporary medical condition, and even an end-of-life situation, if you wanted to be kept on life support or not, those very hard issues. And then lastly, we usually would suggest a living will. So if there's no one available to speak for you, you do not want to be Terry Shabo, okay? If everyone remembers her, or we can go back to Karen and Quinlan. You don't want to be one of those two people. So you want whomever you've named, they're not around, so you want your attending physician to carry out your final wishes regarding end-of-life issues. So that would round out an estate plan for most people. Some people don't need a trust if they don't really have any assets to put in the bucket. I have, some widows that, they live in housing for the elderly, and they just have a Social Security check, and they have one $5,000 life insurance policy that's a whole life policy they shouldn't be paying for. I try to tell them, don't do that, but they think they need to pay their funerals, so it's ridiculous. I try to get them not to do that. They probably don't need a bucket, but a lot of people do, need the bucket. But even without that, it's really important to have the lifetime documents and at least a will. I love to avoid the red place. I have to go there a lot for people who have never planned with me or have not done it properly, so it's really helpful if we can avoid that place. There's 39 of these places in Rhode Island. Anyone know why there's 39 probate courts?
59 cities.
That's right, yes. Each with their own part-time judge who's a full-time lawyer with their own sets of rules. So it's just not fun because you don't know which probate court you have to go to. And this time I won't go to. I sent other attorneys.
So just to rethink.
Yes.
It's important to have a HIPAA waiver,
Yes.
and the power of attorney that I signed 6 years ago is no good. I need to do it again.
It's not no good, but it is. But the IRS isn't really going to accept it. But Rhode Island has a statute that says your power of attorney is valid regardless of the passage of time. But try to convince Wells Fargo or wherever your investments are, who is not licensed in Rhode Island, to accept that power of attorney. It's really important to keep those up to date.
Okay. Every 3 years or so.
I would suggest that, yes.
And can I ask you something?
Sure.
What about if you had some assets you'd sort of forgotten about and they're in a bank somewhere and they're not in the trust? What happens to them?
Those are going to go via this will if we haven't figured out that before you've passed away. Because the will catches any assets that we've neglected to transfer into the trust during lifetime, and it pours over. Correct. Yes. That's a...
What is it you haven't told us because it's Saturday night?
Thank you, Rita. That's the estate plan portion of it. I was going to give you a little information on DOMA and the fall of DOMA and Rhode Island versus the feds, if that's anything that anyone's interested in.
Yeah.
Yes.
So what's the average cost of the trust?
Depends on your personal situation. Depends on if, this is a simple one. If there's tax planning involved, if you're doing estate tax planning, if there's children, if there's other people that you need to do asset protection for, if you even need a trust, if you have a lot of different assets that require funding, and
So it ranges from what to what?
I do everything on a flat fee basis, so I don't charge by the hour. Less than 1,000 to thousands.
Okay.
It really depends on what your situation is.
You mentioned if you don't need a trust. Is that based on your assets?
It's based on the assets or how they're structured or your personal situation. Most of my clients do need a trust, but as I said, that woman that I was talking about in Social Security check, no property, really no assets at this point, and that stupid whole life policy that she's paying on probably doesn't need a trust. It's a case-by-case basis. And particularly if you own a business, it's really important because that's going to cause a probate. You own a business and you have stock or you have an LLC membership interest and you haven't bothered to have that jointly with someone else, which isn't always the best way. That's going to cause a probate for your loved ones just because of stock.
I have a question. Everyone says that going through probate's awful. You said it's awful. Specifically, what's awful about it?
The fees, the inventory tax, oh, and I forgot. If you do it right and no one contests, it takes a year.
So that's the problem, it's not settled for a year. What are the fees usually?
The fees, they charge 1% of all of your cash assets up to $1,500 just for the privilege of probating.
Okay.
And then there's $200 or $300 or $400 to get into probate, and then it's probably just less than $100 to get out. But it's the time factor as well, and there's also a statute of there's a statutory period that you have to let creditors know.
Right.
That even though your mother never had a creditor in the world, you have to keep the estate open for 6 months from the date you're appointed, just to say, gee, my mom passed away and she may have a creditor. So it takes a year to get the money
So it's
out.
$1,000 or $2,000 in a year is the disadvantage.
Oh, it's at least, yeah,
Well, you
it's
said
at
up to
least two.
$1,500 and you said $400 to get
Well,
out.
$1,500 is just the inventory tax. That's in addition. Then you have to add the fees. So 3,000.
Okay. So if you didn't do anything,
If you didn't do anything, yeah,
it's gonna cost you about $3,000 in a year.
depends what your assets are.
Okay, but, you know.
Yeah, I mean, so for instance, if you only own real estate, there's no inventory tax on real estate.
Okay,
But you still have to go through probate, so you'd pay the beginning fees and the ending fees, so and depending upon, whoever handles the estate for you, you could get in and out of that for $1,500. Maybe,
if your partner dies and you owned everything jointly,
yes,
even if you weren't married,
yes,
the living partner still inherits everything.
yes.
So there's no probate involved.
No, there is no probate involved, not in that case.
So if all your bank accounts are joint and all your investments are, I don't know how you do that, held jointly,
You can do that.
or the investments have beneficiaries, so I don't know how that
Yeah,
works.
you can do that as well with a TOD. Mm-hmm.
So there is a way to get the benefit, not go through probate and not have to have a trust.
There is, but you lose a lot of benefits that way, because one of the advantages of a trust over just holding assets jointly and doing the TODs and the beneficiary designations is that you own the assets. And if you become incapacitated, you don't have it set up so that there is someone else. Your successor trustee or co-trustee who becomes a successor trustee can manage those assets for you if you become incapacitated.
Doesn't the power of attorney cover?
Yes, but not if your Wells Fargo or your Merrill Lynch says, I don't want to look at that. Go seek a guardianship over your partner or whomever you're holding the assets for. You never get that argument when you hold the assets in trust. Never. Because you are the successor trustee. They can't give you the
Tell them
argument.
you're the incapacitated one, they'll never know the difference.
I can't do that. I can't do that.
That's how I did it. It worked great.
That's a different way of doing
Don't
it.
tell the lawyer. Yeah.
Yeah, that's exactly. That's close the ears on that.
Okay.
Any more, anything on estate planning? Yes.
When you do a trust, would you do it as a couple or would you do it as individuals?
You do it both ways. It depends upon what your particular asset situation is. Sometimes we do one family trust and you can each own, you own everything together. If you own everything together now, it works really well for a lot of couples, and we put everything into one bucket and you're each co-trustees. You have your family trust. If there's tax issues, if you're worried about your contingent beneficiaries, if they're going to pay an estate tax, whether it's state or federal estate tax, we would recommend two trusts because this is a common law state. So you'd each have your own, but you'd each be co-trustees of each other's trust. So it doesn't matter which bucket I put it in. Okay, I put another bucket here. This is your bucket. This is her bucket. You're each co-trustees of each other's, but this is how we beat the tax man, by keeping the assets separate, so that your contingent beneficiaries can either pay no tax or we can greatly minimize the tax. So it really depends on your individual situation. We do it both ways.
And did you say that 401k and retirement plans would stay out of the buckets?
They stay down here while you're alive with the power of attorney. Retirement accounts are tax deferred assets, so you haven't paid the income taxes on those. We don't put those in the bucket. It would accelerate the income taxes during your lifetime. Okay? You can name the bucket as beneficiary. I don't recommend that for spouse or usually adult children, but for minor children or for any younger people that you want to name as contingent beneficiaries, we name the trust. And what we call is we have conduit provisions in the trust so that we get the stretch out on your retirement benefits at the end of the day. That's part of the funding of the trust, which is something that I go through with my clients in a second meeting, because it's too painful to discuss it in the first meeting after we sign all of this paperwork and kill all these trees. We do that in the second. IRAs is not an issue because you've already paid the income tax.
Right, so again, about
Yes.
right,
Exactly.
about the IRA, again, you mentioned a special power of attorney for the IRA.
Oh, a general power of attorney for the
So
IRA.
cover it.
Yeah.
Just your general power of attorney includes the IRA automatically?
Well, your power, if you have an IRA, then you want your power of attorney to be able to handle any matters regarding that IRA. Now, depending upon where it's held, for instance, Merrill Lynch has their own IRA form, POA form. So in addition to the general power of attorney, it's good to just do that with Merrill Lynch so that you're covered if you have your IRA there.
I think the PIAA has their own.
A lot of the investment houses have their own power of attorney. It's nice to use that with each investment house that you're with, in addition to a general power of attorney. Because the general power of attorney takes care of everything personal to you, lawsuits, dealing with Medicare, Social Security, filing tax returns, everything like that. So it's, you know, it's much more comprehensive than just the one particular to the investment house.
No, he knows it. As long as it's his room.
Good for the Saturday?
Great.
Anything, do you want to hear about DOMA or anything?
I wanna hear about when one partner has children and one does not.
What do you want to hear about that?
Do the children have automatic rights to their mother's assets